Be ready? Start. Article 226 bracket 1 of the Constitution of India, Patna High Court, CWJC number 9422 of 2022 dated 25/5/2023, notwithstanding anything in Article 32, empowers the High Court throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government within those territories, directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them for the enforcement of any of the rights conferred by Part 3 and for any other purpose, and it also envisages making of interim orders, whether by way of injunction or stay or in any other manner in which a proceeding. Article 21 giving protection of life and personal except according to procedure established by law for enforcement of one's right to life and personal liberty resort to Article 226 bracket 1 has thus been provided for. What is the ambit of enforcement of the right? The word enforcement has also been used in Article 32 of the Constitution, which provides the remedy for enforcement of rights conferred by Part 3 of the Constitution. The word enforcement has not been defined by the Constitution. When right to personal liberty is guaranteed and the rest of the society, including the state, is compelled or obligated not to violate that right, and if someone has threatened to violate it or its violation is imminent and the person whose right is so threatened or its violation so imminent resorts to Article 226 of the Constitution, could not the court protest observance of his right by restraining those who threatened to violate it until the court examines the Patna High Court CWJC number 9422 of 2022 dated 25/5/2023 legality of the action. Resort to Article 226 after the right to personal liberty is already violated is different from the pre-violation protection. Post-violation resort to Article 226 is for remedy against violation and for restoration of the right, while pre-violation protection is by compelling observance of the obligation or compulsion under law not to infringe the right by all those who are so obligated or compelled to surrender and apply for a writ of habeas corpus is a post-violation remedy for restoration of the right, which is not the same as restraining potential violators. In case of threatened violation of the right, the question may arise what precisely may amount to threat or imminence of violation. Law surely cannot take action for internal thoughts but can act only after overt acts. Overt acts towards violation have already been done and the same has come to the knowledge of the person threatened with that violation, and he approaches the court under Article 226 giving sufficient particulars of proximate actions as would eminently lead to violation of right. Should not the court call upon those alleged to have taken those steps to appear and show cause why they should not be restrained from violating that right? Instead of doing so, Patna High Court CWJC number 9422 of 2022 dated 25/5/2023, would it be the proper course to be adopted to tell the petitioner that the court cannot take any action towards preventive justice until his right is actually violated, whereafter alone he could petition for a writ of habeas corpus? In the instant case when the writ petition was pending in court and the appellant's right to personal liberty happened to be violated by taking him into custody in preventive detention, though he was released after 4 days but could be taken into custody again, would it be proper for the court to reject the earlier writ petition and tell him that his petition has become infructuous and he had no alternative but to surrender and then petition for a writ of habeas corpus? The difference of the two situations, as we have seen, have different legal significance. If a threatened invasion of a right is removed by restraining the potential violator from taking any steps towards violation, the rights remain protected and the compulsion against its violation is enforced. If the right has already been violated, what is left is the remedy against such violation and for restoration of the right over.